We're discussing the landlord advantage that you want, that you've already got. And so I'm going to start this particular session. I'm going to break it up into 3 parts since I'm going to have 3 different rounds of people. But here we're going to talk a little bit about the landlord advantage as a gatekeeper to the property. I tell my whole staff, this is what we're actually dealing with. We're dealing with our client's most valuable asset. They've got a house that they use and they put in the hands of a complete stranger. And that's something that we need to take seriously. When that house is in jeopardy, we got to come in and run to the rescue. But when you're a gatekeeper, you can prevent jeopardy from ever happening. And that's one of the advantages that a landlord has, is you have a gatekeeper responsibility to your own investment. And so one of the ways that we gatekeep is by doing in-depth screening. And what this requires is not just a credit check, not just an application where, oh yeah, these things look good. It requires diligence. Let me give you an example of something where a little diligence would have gone a long way. Because I get this a lot. Somebody comes into my office and says, Ernie, I can't believe my tenant all of a sudden stopped paying. It turns out they don't work at the place they said they worked. They don't make the amount of money they claimed that they make. And so now 4 months into the lease, I haven't gotten rent. And I don't foresee getting rent again and again. What do I do? Well, naturally, there's the eviction process. We'll send notice, we'll file. But that's a 30 to 45 day process. You can pretty much bank you're going to lose another month or 2 of rent. But what if you could have prevented that with a simple phone call? Sure, they're going to list something on that application that says, I work at, 123 Industrial Way. Well, what stops you from going on Google and looking up that company and confirming, does Joe actually work there? Yeah? Does Joe make at least X amount of dollars? Because he says he makes at least 3 times this amount. I don't need to know Joe's salary. I don't need to know. I just need to know that I can confirm at least this number. No? Oh wow, he makes far less than that. Okay, no problem. Thank you so much. Denied. Right? Or sometimes, this is my favorite one, sometimes we call the number and we hear doo-doo-doo. I'm sorry, the person that you're renting to lied to you. See you later. Good luck in eviction court. Click. Because these are real things that happen. People are so brazen. People will show up with made-up bank statements, fabricated W-2 forms, fake references. It's very easy to lie on paper. And so we, as the gatekeeper, have to be more diligent when it comes to the people that we're handing over those keys to. Because again, that's a $200,000, $300,000, $500,000 investment, and you're just handing over the keys to someone who has lied to you right from the jump. If you can prevent that, you're likely to prevent yourself from future losses. And that's what gatekeeping is all about. Protect that investment and do a little bit more to make sure that the person who's coming in there is truthful. Another way that we can protect and gatekeep is by having a conversation with our prospective tenants and letting them know, for example, look, this is my philosophy when it comes to management of the lease. If by day 7 I haven't gotten a full month's rent, I'm going to issue a notice to vacate. And I'm sorry if things go wrong. I know real life happens, but my anticipation is that your earnings and your financial position are such that you will continue to pay rent even though real life happens. I understand that things pop up, but unfortunately, that thing that pops up is ultimately going to have a negative impact on me and my business. I still got to pay taxes. I still got to pay a mortgage. I still got to pay insurance and upkeep and all sorts of things that won't stop even though life got difficult for you. I'm certain this isn't going to be a problem, but please understand that if we're at day 7 and you have not paid the full amount of rent, I'm going to have to issue a notice to vacate and begin the eviction process. By having an honest conversation with that tenant, you prepare them. They know this guy's serious about the rent. So not only am I going to pay it by the 7th, I'm going to pay it on time every single time. And by being willing to have a difficult conversation, you're going to spare yourself from the uncomfortable position of losing money for weeks and months. Your willingness to do this, to protect that asset right from the start by having this difficult conversation, will prevent late payment. Or when it does happen, they understand that notice to vacate is serious. And unless they cure that default, they're likely not going to have a place to live. And so by making this crystal clear and not be wishy-washy with your own terms, you're going to protect that asset and you're going to ensure that you remain profitable.
Can you do that notice like right away after the first 7 days that you're saying, and issue it? Does it have to be by certified mail or can it be by hand?
That's an excellent question. So we always recommend that you deliver any document that you think might eventually end up in front of a judge, deliver it by regular mail and certified mail. So the property code has very specific things to say about the notice to vacate. Regular and certified mail are definitely approved. If on top of that, you also want to text it, you want to send it by email, you want to attach it to a banner and fly it from a plane through the city of Houston, you can do all of that. But the only ones that really count are the ones that are approved by the state, and that's always regular and certified mail. And you might be asking, well, isn't that overkill? Why would I send it both? Well, you send it both because certified mail can be tracked and regular mail cannot be rejected. So we know if you mail them both at the same time and either you confirm the delivery of that certified mail or the record shows that delivery was attempted on a certain date, you know 2 letters go together, one's attempted delivered, the other one is definitely delivered on that date. So you have evidence that the letter was delivered. And so courts love it when you do it by regular and certified mail. I've actually had a court turn away a landlord who claimed he gave the notice to the tenant and the tenant said, no, he didn't. Tenant said, I never took it. I never took it. Put my hands just like this, never took it. It's he said, she said, and that's exactly what the judge said. He said, it's 50-50. You say yes, they say no, you're 50-50. Your burden is by preponderance of the evidence, just slightly more likely than not. When it's even, you don't meet that burden, and so you lose. Start the whole thing over. Whereas the U.S. mail, I got a receipt, I got the tracking, I'm done. That's all I got to prove.
Because you give them all the information they need to check through this plan.
So it's going to depend on what kind of relationship exists between the realtor and the landlord. Is the realtor also serving as a property manager? There's a line near the end that says nope, or it says yes, right? If the realtor is not serving as a property manager, then they just facilitated the creation of the document, and that's where the liability ends, right? But if they say, no, I'm the manager, contact me for notice, contact me for repairs, contact me for all these things, then they assume additional responsibility, probably for money. And so, yeah, their liability would extend in that situation, but not otherwise.
When it's a realtor landlord, is there a higher expectation placed on me because I should know more about real estate or so on and so forth?
So the Texas Real Estate Commission might hold you to a higher standard in certain aspects, so that if, for example, a landlord said, I had no idea I was committing fraud, that might go over better than if a realtor tried to say, I had no idea, because you're educated and you're expected to operate under knowledge of the law. And so not like an attorney, but if you knowingly misrepresent some fact, you could be held to a slightly higher standard, but generally speaking, no.
I'm an insurance nerd. How does insurance tie into any of these cases, if it ever has been?
Great question, especially after the hurricane. I had a client who came in and said the roof of the house went up and wrecked right over a car, her tenant's car. And the tenant said, you got to get me a new car. Because guess what? He had no insurance for the car and he had no renter's insurance. And my client was like freaked out because she didn't have insurance. She was in between policies. She said, my insurance a month before said they were terminating the policy because they needed some upgrades. I was looking into those repairs and had not secured new insurance. What can I do? Well, here's the thing. Zero liability for acts of God. It was in the lease. If you are harmed by the good Lord, That's between you and him. That's not between you and the landlord, because acts of God are disclaimed in the lease. So wind, rain, hail, fire, flood, any of these things that happen, these are casualty losses. And the landlord assumes no responsibility for your personal property when it's damaged in this way, or when it comes to the real property, the extent of the liability of the landlord is if the property is 100% uninhabitable. No roof, 100% uninhabitable. You can terminate. You have to deliver to the tenant a refund of the rest of the month's rent, and you have to give them back their security deposit. That's the extent of your liability. That is it. That is literally it.
And you choose not to do that, and then that tree damages my property, and it was because of that act of God. Explain to me the process then.
It's a great question. This came up a lot during the storm. So, healthy tree, God knocked it down, crushed your patio, it's on God. Dead tree, obvious rot, that's on the owner. If that tree started on there and you say, look, this is a dangerous tree, not because of its health, I mean, not because of its breadth, right, how big it is, but because of its health. And so when it is open and obvious that the tree is diseased or dead, they have a responsibility once they have notice of it. So notice is also key. And here's the thing, if it's open and obvious, you have what we call constructive notice, right? But a healthy tree, and there were a lot of healthy trees that came down on other people's houses, no liability in that case.
Insurances are very tricky though, because they will pay for a tree that falls on the property that wasn't even hurt, which sucks.
Well, but yeah, your insurance will cover damage to your property if a tree flew 3 blocks over and then crashed.
Somebody else's tree.
Somebody else's tree.
Yeah.
Your policy should cover that.
Turns it up, it looks like it's on purpose, and he, without, notifying the landlord, and doesn't pay the landlord's rent. What does the landlord do? That happens all the time.
It does happen all the time, unfortunately, and that's another part of gatekeeping. You only want the best possible tenants who are the least likely to do this sort of thing. But let's say it turns out they turned and they were good for 11 months, and month 12 they went right down the crapper. Who knows why? But they did. So you have a couple of options. Number one, for the damage, that could be an insurance claim if you have protection from vandalism or from willful destruction. That's not usually in your normal homeowners or even landlord's policy. You usually have to get extra coverage for vandalism. Okay? The other is you could go after that tenant. But if that tenant doesn't have 220s rubbing in their pocket, it's worthless. They're what we call a judgment-proof tenant. That even if you want a judgment for $50,000, $60,000, $70,000, it's a worthless piece of paper because you can't execute it against them.
And he was the only one here, and the microwave was destroyed. He used I don't know what he used, but he damaged my property. Is that criminal mischief?
I don't know. What I do know is you can probably prove that in a civil law, but criminal law has a much higher standard. It's not more likely than not. It's beyond a reasonable doubt. And if he says, hey, I moved out, somebody must have come in while I was gone.
Gotcha.
So you have to be more definitive in that proof. So harder proof. And you don't get to decide what the DA takes on.
10-4.
If the DA says, I'm not taking that case,
Yes, sir.
it's dead.
And it's been encroaching for 10 years. Isn't there a certain amount of time where it's like, hey, Eddie allowed this to happen, and my central unit has been there so long? So
It's essentially, you either get an easement because you just allowed it, or that's a new piece of the property.
Gotcha. Thank you, sir.
Yeah, it's called adverse possession.
Adverse possession. Thank you, sir.
Now I want to talk about the landlord advantage when they are managing their property. What sort of advantages does the law give to landlords who are managing their own property? And so one of them is pretty clear. You get control of that lease. Typically, you're the one drafting the lease. In a very rare occasion, a tenant will draft it, and I would never recommend that a landlord entertain a tenant-drafted lease. I've only ever seen those be miserable failures. However, because you have the control to decide what lease is signed, you can use a lease that has some excellent provisions that state law will allow. One of them is one of my favorites, the application of funds clause. Sometimes I have clients who come in And they say, Ernie, I've got this guy, he didn't pay rent for the month of July, I want him out. Okay, well, let's go through your rent ledger and see, well, he didn't pay in July, and he didn't pay in April, and he didn't pay in January. And he owes me late fees from February, and he owes me a broken window fee. I paid for that repair, he paid for that. I paid for that repair, he broke it. I issued him a bill in June, he still has not paid me. So see, the problem with that is you just rattled off a lot of fees. And it sounded like there were months when he did pay the rent. And so what the application of funds clause in a good lease will say is the following. It does not matter what you mark on a payment. I can apply this payment first to unpaid fees, non-rent obligations first, and then any of the balance to rent. So that every time you get money, you apply to the oldest debt first. Don't leave gaps in your ledger. I often show landlords, when you fill a bucket with water, it fills from the bottom up. It never leaves gaps just because you took a break and waited a little bit and then kept going. No gaps, it goes right to the bottom and just keeps filling all the way to the top. And we should treat our rent ledgers that way, especially if your lease has an application of funds clause. Cure all that old debt, and then that same month say, thanks for paying the late fees from last month, thanks for paying for that broken window from last month, but your rent is short. And they may say, whoa, no, I paid exactly what rent is owed for this unit. And you say, well, you did, but you owed more than that. And so because you owed more, I applied your payment first to the old debt, and your current debt, your rent, remains unpaid. Please pay the balance or I'll be forced to evict, right? And so my policy that I preach to all landlords is 7 days. Is if by day 7 you haven't received every penny of rent, you got to issue that notice to vacate. Because statistically speaking, beyond day 7, it becomes increasingly unlikely that the following month will be paid on time. And all you do is you start a snowball effect of non-payment and usually other lease violations. The best tenants will always get their rent paid within the first 3 days. Occasionally they're going to need a little bit of time and they might get to day 7. But the worst tenants always go beyond day 7, every single time. And so by knowing that as a barometer, day 7 is the absolute latest. You get to day 7, you're issuing that notice to vacate. Because you're better off getting rid of a bad tenant early in the process than just kind of dealing with it month 3, month 6, month 8, month 11, and then you get to month 12 and they won't leave because they don't respect the boundaries that are in your lease. But guess who has to respect them first? You do. As a manager of your property, the advantage you have is all of the benefits of termination if the tenant defaults. But if you don't exercise that advantage, you will get taken advantage of every single time.
So you're saying 2 separate things, certified and regular? So, but how do you prove that you sent a regular if there's nothing?
So for us, super easy, because we have a stamps.com account. We just print out that report. It shows the name and the address of the person who went to. When you go to the post office, if you don't have a stamps.com, you get this, and I really love that they do this. It's a long white sheet of paper with numbers and letters and information on it that says, first class, certified. It has a price and the date and the branch where it was mailed from. And so by using that simple thing, that receipt, evidence. And then of course you can go and you can pull that report because you've got that 37,000 number code. You punch all of that in and it'll yield a report for you. Print that out, take it with you. Yeah, and so with the certified letter, the problem is that tenant that's never going to go get that letter. And so you're going to have some judges who'll say, you know what, they had the opportunity, I'm going to deem them having had constructive knowledge. But other judges are going to say they had no idea what it was. And because they were never notified, you didn't give good notice, start the process over. But when you mail them both, they had both the opportunity and confirm receipt. So always both. Always both. Certified sounds good, except in practice we know that 80% of them never get collected. I know that because they all come back to me. Yeah, or 80% of them do.
Very difficult for him to access that to evict them. Is there any way to avoid that in the future?
Well, the lease itself should say you're not allowed to conduct criminal acts on the property. It probably should also say you're not allowed to conduct business of any kind on the property. So the question though is, can you prove that an illegal act was occurring? So here's an easy one. Domestic violence. Husband, wife, they have a spat. It spills out into the courtyard. You son of a this and you mother that. Everybody hears it. The call is made to the police because some little old lady was like, no, you got to come. The police come. They file a report. Evidence, 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 evidence. In this case, guy's dealing drugs, and everybody knows it, but there is no evidence. There is no criminal arrest. There is no report. There's no conviction. It's going to be hard for you to prove to the judge. I once had a tenant that I represented where the property manager said, I came into the unit, I looked, and I saw a blunt in an ashtray in the unit. And my question was, how do you know it was a blunt? Well, I know these things. Okay, what kind of criminal training do you have, or what kind of chemical training, or what kind of drug training do you have? Other than, yes, that's the implication, other than your own personal experience. And she says, well, I have none. Well, then you also have no proof of what you think you saw. It could have been a rolled cigarette, right? Grandpa used to do the old bugler cigarettes, right? Roll them himself.
Oregano.
I don't know what that is. It could be oregano. He just puts his spices in little wrap pieces of paper, saves them for later. Yeah. I don't know. But the burden is on the landlord that more likely than not that's what it was. So, well, I smelled it. Well, what does it smell like? Can you demonstrate to the court a smell? You can't. Wow. And unless you have some kind of expert knowledge of it, maybe the cop came in. Again, report. And the cop detected the odor of marijuana. That's better. That's more likely than not evidence of a criminal act. In this case with the drug deals, unless there was some, again, confirmable evidence, probably can't do it. Yeah, and that's what makes it tough.
Lease contract to use, or should property managers create or have an attorney draw up their own leases?
You should always go to the law office of Ernie Garcia and purchase your own lease. So there are two basic, very widely used forms in the state of Texas. The first is the TAA lease, the Texas Apartment Association lease. It's an excellent lease, and it covers apartment units, right? More than 4 units in a building are considered multifamily, and so it's an excellent lease for that. The other lease is the Texas Realtors lease, or the Texas Association of Realtors. And that lease has been around for a gajillion years, and it is also an excellent lease. So there's very tried and true leases that have been in Texas courts for decades. And so do I recommend them? I give them my stamp of approval. They're good leases. Now, you have to be parts of those associations to use them, and if you're not, you don't have access to them. So Joe Landlord, who's not also a realtor and not a member of the association, cannot technically use that lease. So in that occasion, he could either hire a realtor to represent him for the purposes of drafting and executing the lease, or they can seek out an attorney and purchase their own that they can use over and over and over again on their own without the association.
What do you recommend as far as ownership of the home? Should they be setting up LLCs to purchase a home? Or
Maybe. So the best way that somebody can protect themselves is to buy the right insurance. A number of times you'll have a situation where somebody was living in a house, so you know what, I'm going to buy another house and I'm going to rent this house. So they do that, but they never change their insurance. They have a straight homeowner's policy, not a landlord policy, not one that anticipates tenants and their invitees. Guess what? There's probably a provision in that insurance that says you can't rent this to other people, only you are covered. And if you are not the one living there, no coverage. So you always want to get the appropriate insurance for leasing to other parties. That's the best way. And if you currently have a note, a loan on that property, chances are very high that there's a clause in it, a due on sale clause. It says, if you transfer this to an LLC or to another party, really, without my written permission, says the bank, I can foreclose. So you want to make sure that if you are in that situation where you do want to set up an LLC to gain a little bit of anonymity, maybe, you're going to want to get permission from the lien holder and just say, I'd like to do this. I'm the sole owner, or my wife and I, who are the co-owners, are the co-owners of this LLC, and we'd like to transfer this over just for liability purposes. And as long as they say that's okay in writing, if they don't, you run a risk.
If they're asking, like, before I purchase the home, how should I set it up prior to the purchase?
Yeah, they can come see me. Generally, I'm set up. I can set up a single member LLC. If it's more complicated than that, usually 2 or more people are probably going to need an operating agreement, and I have a business law attorney who I would refer them to. Some CPAs can also do the work. Now I want to talk about the landlord as a defender of the most valuable asset they may own. And when people come to my office, I often let the staff know that our whole thing is we are defending people's most valuable assets. They've got a $200,000 or $300,000 or $400,000 property that they're putting in the hands of a complete stranger. How do you defend it when things go badly? Well, number one, you got to be on it. You can't let things linger, whether that's repair issues. I was reading a post or a response on something that I did online, and the guy says, it's been 11 years since I gave the keys to the tenant. I haven't been inside that house once. That's poor management. Well, how do you defend in that case? Well, you got to end that lease. You got to get in there. You got to see what's going on, because he says that the tenant won't let me in. Let me tell you, a tenant is not allowed to bar you from the door. If they do that, issue immediately a notice of default and say, I'm coming in. State law says I can come as long as the basis is reasonable and my manner is peaceful. And so you set a date, you show up. If they say, nope, you're not coming in, say, fine, I'm turning around. Because at that point, the peace is broken. So you say, well, I came by, you didn't let me in. Violation. I'm coming again in a week. Happens again, violation. Happens again, violation. I preach a 3 strikes and you're out policy. Even if the rent is paid, if they have barred the door 3 times, you have to defend your property. You have no idea what's going on in there, but after 11 years, it's probably something really bad. And if their whole goal is to exclude you, it's probably because there's something in there they know you're not going to like, right? And so, as long as it's perfectly reasonable for you to go in, you should go in, because you want to defend your property against harm. The classic one is the leak from the ceiling. You ever seen a leak on a ceiling that starts off like a little circle, and then it turns into a slightly bigger circle, and a slight, yeah, and then eventually that thing's gonna fall if you wait long enough. That happens either because the ceiling, the roof has a leak, or because the AC's drip pan is overflowing. Common things that if you catch early, you fix early. And maybe it costs you a few $100s as opposed to a few $1,000s. And so you have to defend your property, you have to defend your pocketbook from those kinds of things. And sometimes you have to defend your property from just tenants who don't pay the rent. And you gotta know, what am I gonna withstand in terms of how long it's gonna take for me to get rid of a tenant that just isn't paying? Well, in Texas, we actually have a pretty quick turnaround on evictions, but even it is 30 to 45 days in the original justice court. You gotta file them all in the justice of the peace. 30 to 45 days, which translates as a month to a month and a half of lost rent, minimum. So if you already waited 4 months, you're just going to add another month and a half, 2 months to that loss. So don't wait that time. Even if they beg and plead and say, hey, I'm going to have this in 2 weeks, great. Because, let's do the math here. If you're at day 7, they haven't paid the rent, I recommend handing a notice to vacate. Now they promise 2 weeks I'm going to have the whole thing. We'll see. You go ahead and you proceed and you start with the eviction process. 2 weeks later, they come with the rent. Do you take it? Well, here's what you already know. We're 3 weeks in. What's right around the corner? The very next month. And you know, if they struggle to get this, there's no way in 10 days they're going to have the next month's rent. So you got to make a decision. Am I just kicking the can down the road, or am I removing a tenant who obviously cannot afford to live on the property and just say, look, we can make a clean break, you can find a new place to live, but I can't keep you here. This is not going to work. And so by getting rid of tenants who obviously are not a good fit, this isn't a judgment on their moral standing, it's not a judgment on their character, it's an economic decision that they can't afford your space, and that's okay. If you misjudge them as a gatekeeper and you mismanage them as a manager, don't fail as a protector, a defender of the property. At a certain point, you're going to have to pull the trigger and say, this has to happen. I have to get rid of someone who's not only harming my property, but harming my pocketbook. But you have to be willing to do that. There's so many landlords who are so averse to confronting, like they can't even consider the idea of knocking on the door and saying, hey, can I have money, please? It's almost like it's beneath them, or it's shameful to ask for money or to ask for permission to get into their own property. You got to get beyond that. If you're going to be a landlord, you got to have the skin that's thick enough to withstand that kind of uncomfortable conversation. So let's talk about what it means to defend.
Yeah, if they do talk to them.
Hello, honey. in a little bit. Let's talk about what it means to defend the property and use your legal advantage to defend that property. Well, naturally, I'm going to talk about eviction, and ultimately, you can't be scared of the eviction court. It's unfortunately one of those ugly things that we have to do, and really, it's important to know why eviction itself is one of your best tools as a landlord. Because if you're serious about the potential for an eviction, your tenant has to know it before they ever enter the property. They have to know, I hope it never happens, but if we don't receive rent by day 7, I'm going to issue a notice to vacate and begin the eviction process. I'm sure it's not going to be a problem. But unless you're willing to say the word eviction, you're never actually going to do it. And I have so many people who feel a kind of guilt when it comes to enforcing their lease. Well, I know it's been hard, times are tough, and yada, yada, yada. Yeah, you know what? It's been hard on all of us. It's been tough on all of us. That's not an excuse we can take to our mortgage company. It's not an excuse we can use to the taxing authority or to the insurance provider, all of whom went whoop, 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 right? And so the landlord has to cover their costs. And the landlord is under threat of losing that property. So if you want to defend the property, you have to be willing, when it comes to it, even to evict. And so how do you do that in your area? Well, the first is you got to be familiar with your courts. And so all evictions happen in the justice court, the justice of the peace, where the property is located. In Harris County, there are 8 precincts. 8 precincts all over the county. Now, each precinct has 2 places or 2 judges. So if you are closer to one, or maybe you are more familiar with one than to the other, you're not required to choose between them. You can choose between the one that you prefer. For example, for years and years and years, I lived in Spring, and there's a court in Precinct 4, Harris County, right there in Spring off of Cypresswood Drive, where I would take many of my cases because I was more familiar to that than I was to the Humble Court. Same precinct, it's the top part of Harris County. It goes from Kingwood all the way to Tomball, a little bit of Tomball, but Spring, and then you go as far west as the county stretches. And so by knowing the courts and being familiar with it, you know where to file. But if you've never done it before, it's going to feel scary at first. So one thing that landlords can do that's extremely helpful is just go into the court. They're public forums. If you've never filed an eviction before, don't let your eviction be the first time you see an eviction. Go into the courtroom, sit down, watch. And if you're lucky, you might be able to ask questions even of the judge and say, look, I'm interested in filing an eviction. I've never done this before. Where do I go? The people are quite helpful, you're going to find, most of the time. And so when you go to this window, you go down the hall there, and the people who are there will help you. They have forms, they have all sorts, they can give you limited amount of information. They certainly can't give you legal advice. For that, you're going to come to an attorney. For experience, you might go to other landlords. But to see the process, the only way to do it is to sit in a courtroom and just watch. It's an extremely helpful thing to see somebody else do it, to hear the kinds of things that tenants are going to say, and the kinds of things that judges are going to say in those events. That experience is so helpful and extremely valuable. If you've never done it before and you're petrified about the idea of filing an eviction, I strongly recommend go in, sit down, and watch an eviction. You'll be shocked how many answers you're going to get just by sitting and listening.
Those are kind of tricky. Well, not tricky. There's just no way. You're basically at the landlord's whatever they want.
At their advantage. That's exactly right. And really, the market will dictate what makes sense. Let's say you're in the middle of the summer, and you know I've got people who are asking me right now to rent this house. So if you left, it would take me a few weeks to replace it. But let's say instead it's December 20th. I'm not going to find somebody for a month or two. Nobody moves in the middle of winter, or very rarely, and so the pool is much smaller. So you as a landlord have the advantage of making that decision. Because here's the truth of it. The tenant owes from day 1 to day 365. They're on the hook for the whole term. And so if you want to end it soon, it's got to make sense for the landlord that, look, I'm gonna have losses from this. If you have something to gain, like if you want to buy a house or something, then just cover the losses and we're good. And it's got to be a reasonable determination. So I tend to tell landlords, don't put a default in there because you never know what the market is going to call for. You don't want to be stuck saying, I'll take a month and a half, and then it takes you 4 months to release.
They want to put someone else on title, but they can't because the lender won't allow it. But then they want to put them after the fact. They want to add them, like let's say their mom or their son.
That might be a breach of the loan agreement, because by doing that, they kind of sidestep something that the lender didn't want in the first place. They have a due on sale clause that says if you transfer the deed in any way without our written permission, we can immediately foreclose.
Would that be an additional documents or closing documents, or would that be included in the deed?
It's going to be in the promissory note.
They want to comply with contract and some repairs that the lender wanted. So I had to file a memorandum of contract, but you know.
So when we come in on that, what we'll typically do is we'll send a demand letter. They don't do it, we'll file the lawsuit, and then what's called a lis pendens. And a lis pendens basically says there's trouble with this property. So if he tries to sell it, title's going to find it instantly. Yeah. So it functions like a memorandum, but it's stronger because it's pointing to actual litigation.
Gotcha.
So that's what we recommend.
Okay.
Generous or by waiving late fees, is that true? I mean, and to what extent?
So let me handle the second question first. It's the one most on our minds.
Okay.
So many leases have what's called a non-waiver clause, and that non-waiver clause says I may have waived something 1,000,000 times, but it doesn't remove my authority to enforce it at any time whenever I want.
Wow, okay.
So that's what the clause says. But in practice, you put that in front of a judge who says, wait a minute, they were your tenant for 3 years, they paid late 27 times, and on the 28th you wanted to charge them something? I'm sorry, I just can't see that as fair.
Okay.
And so in practice, you may find that the court applies this doctrine that we talk about sometimes. It's called the doctrine of latches. And what latches says is, if you sit on your hands and you don't do anything about it, why would the court?
Yeah, okay.
You know, if you don't enforce your own rights, then by course of performance, you have altered those rights. That's where you hear that. And so, generally speaking, if you argue the contract and it says in black and white, no waiver, some judges are going to side with you, other judges might not. So you have to be ready for that.
It's called a waiver clause?
A non-waiver provision. Yeah. Now, what I preach is a 1-3-7 policy. 1-3-7. I already told you about 7. 7 days. If they have not paid the rent, in 7 days you got to issue a notice to vacate. That's too long. 3 strikes and you're out. If I've had to notify you of 3 defaults over the course of your tenancy, usually 12 months, that's too much. At that point, I have to strongly consider a notice to vacate because this might not be a good fit. And the one, I believe it's perfectly okay within a 12-month period to forgive one sin. If you're constantly forgiving sins, you're not their priest. right? You know, and while it might be nice, it's bad business to forgive and forgive and forgive, and to let, you may as well take all those late fees. Let's say it amounts to $500. Take $500, put it in a bucket, light a match, and set it on fire, because that's essentially what you're doing. You're losing money. And if losing money was how people made money, so many of us would be super rich, because most of us lose money. Only the people who know how to enforce those agreements actually are successful in this game. Now, as for Section 8, Section 8 probably is going to require notices to be sent to the housing authority. So when it comes to a notice to vacate for a Section 8 property, because there is government funding, we have to go to the 2020 to the USA CARES Act, where they signed into law a provision that says if you accept funding from the federal government for housing, or if you have a federally backed mortgage, Freddie Mac, Fannie Mae, any notice to vacate has to be minimum 30 days. That's another big Section 8 difference. So not only are you likely supposed to send the notice also to the housing authority, you probably have to give an extended period of notice to those tenants, 30 days minimally.
It goes to the housing authority? I'm sorry, just to...
You should have a housing liaison.
Okay.
The person that you contact about the house, so probably the person you sent the...
And I would know that if I ever did Section 8. I guess.
Correct.
Sure.
You would have a contact person. They're the ones you sent the lease to. They're the ones who probably set up things like inspection of the property to make sure it's up to code.
Got it. Okay.
And things like that. So, and they're the ones who are going to update you if the funding goes up or down, what the contribution of the tenant's going to be, all those things. You're going to have a contact person.
Perfect.
For sure.
Okay, thank you.